So we've gone through the first source of international law, which is to say customary international practice. Now we turn to the second source, and that is treaties. Treaties and international conventions. Well, what are treaties? Well, a treaty is a legally binding agreement between two or more nations. It's a legally binding agreement, somewhat like a contract, but stronger than a contract because a treaty establishes the law. Now, there are different types of treaties, and the first is bilateral treaties. These are the most common type of treaty, and as you might guess, these are treaties between two countries. And right now in the United States, the current administration has taken the position that bilateral agreements are strongly preferred to multilateral agreements. Multilateral agreements are open to all states or members of a large regional group. So everyone in the world, for instance, the Convention on the Law of the Sea, or the Convention on Contracts for the International Sale of Goods, those are multilateral agreements because they're open to the world. Anybody who executes the treaty is then bound by the terms of the treaty. And the way you can think about these is that a bilateral agreement is more contractual in nature. It looks like a contract. It looks like it sets out obligations and responsibilities on the two parties to the agreement, to the two parties of the treaty. So a bilateral agreement is contractual in nature. A multilateral agreement looks more like legislation. It's legislative in nature. So even though these are both treaties, this looks like the law is passed by a governmental entity. So it's legislative, it has this legislative aspect that distinguishes it from a bilateral agreement. Now, treaties are governed by the United Nations 1969 Vienna Convention on the Law of Treaties, which is a treaty about treaties, a treaty that sets out how the world is going to view treaties. So when we talk about what does a treaty mean, we're relying on a treaty that described what exactly treaties mean. Now, treaties can be formal and generally are, but they could also be informal. So even an oral agreement between the representatives of two countries could rise to the level of a treaty, even a simple oral agreement. Now, I said treaties can be classified as either lawmaking or contractual. Generally, that refers to multilateral versus bilateral. And we know that a treaty can either be self-executing, meaning it goes into effect immediately, or it can be implemented by national legislation, in which a national legislature, a domestic legislature, will do what it is that the treaty has set out for it to do. We see this in the European Union a number of times, wherein the European Union can act, and in so acting, they send a directive to their member states that those member states should pass domestic legislation that reflects the treaty terms. A self-executing treaty is the law when it is ratified. There's no need for an action by a national legislature. Now, treaties come into existence in stages. The first step in treaty creation consists of negotiation. The parties negotiation, representatives of the parties negotiate the terms of the treaty. And this is a long process, generally takes months and months, until eventually a draft is decided upon, at which point representatives of the country each sign the treaty, the draft treaty. So signature actually takes place before the treaty goes into effect. Signature simply says, this is the draft of the treaty, this is the final draft of the treaty that the countries will now have to decide whether to ratify or not. And ratification refers to each state's full acceptance of the treaty. So once the treaty is signed off on, then it goes to the individual state, the country, to decide whether to ratify it or not, to accept it in full. Now, when I say ratify it or not, a country may ratify a treaty but insist on certain reservations. So a state can sign off on a treaty, but they can create exceptions to that treaty that says this will not apply in certain instances. We've mentioned the United Nations Convention on the Law of the Sea several times. The Convention on the Law of Seas was executed, and one of the parties executing it was China. But China said this is the law that will apply to matters contained within the treaty, except that it will not pertain to any matters of sovereignty. So as we'll talk about, and there will be another presentation on this involving the South China Sea, China refused to recognize the decision of the arbitration panel in the dispute between the Philippines and China by saying that they had not agreed to be bound by a decision relating to sovereignty. Now, the next phase of the treaty is entry into force, and that's when the treaty actually goes into effect. Now, I should point out here that the United States deals with treaties differently. And so there's a lot of confusion not just among the public as a whole, but the government as well. And many of your senators and congressmen are not aware of the distinctions between treaties, and they are not aware of how that distinction plays out in the international arena. Now, in the United States, we have two kinds of treaties. Well, we actually have three, but for our purposes, we can say there's two broad divisions: a treaty, a constitutional treaty, or an executive agreement. An executive agreement is an agreement in which the executive branch has negotiated the terms of the treaty and has bound the United States by its execution of the treaty. Now, when we talk about a treaty, again, shorthand, we refer to that as a constitutional treaty. A constitutional treaty, but we call it that because it's mentioned in the Constitution, requires the advice and consent of the Senate, meaning in order for it to be a treaty, according to the Constitution, there has to be approval by the Senate. And you often hear about this: the Senate needs to ratify the treaty. The treaty is not effective until the Senate ratifies it. Well, that's true, but only for constitutional treaties. That in fact there's another kind of treaty, the executive agreement. Now, the important thing for you to understand, and this is what a lot of people get confused with, is as concerns the whole world, there's no difference. They are both binding international law. So an executive agreement, even though it doesn't comport with what the Constitution says, is equally binding international law. Now, why do we have this? If the Constitution sets out the rules for a treaty, then why not just use the constitutional definition? Well, the problem is it doesn't work in real life, that in our system of government, because we have become so polarized, the Senate would never actually ratify an agreement. It would be very difficult, I should say. They will do it, but it has to be something along the lines of human trafficking in order for there to be enough Senate support for the treaty to actually ratify it. And we see this many times when proposed international treaties are submitted to the Senate for confirmation, for ratification, and the Senate refuses to do it, even on a treaty that's not really controversial. There was a treaty back in the early 2000s involving the treatment of handicapped individuals, and this treaty was very non-controversial, and it contain the same law that was already the national domestic law in terms of how we deal with disabled individuals. Nevertheless, it was unable to get enough congressional support or support by the Senate in order to be entered into law. So what we've done is we've come up with this backhand way of creating a treaty, which is to say we'll leave it up to the president to make the treaty. However, understand that that treaty is to the rest of the world just as binding as a constitutional treaty. They are both binding international law. And when you violate a treaty, whether it's constitutional or executive, it's the same. It's the same in terms of violating international law.